Quite often people ask me, how long does it take to get a divorce? Well, that depends. If you and your spouse can talk and y'all can agree on all the issues, I mean everything, we can prepare all the documents and have you sign it, file them with the court. There's a minimum 30-day waiting period, and shortly thereafter you can be divorced. You may not ever even have to see a courtroom. However, if there's anything the two of you cannot agree on, then you have a contested divorce, and it can take quite a bit more time. Generally, once we file, if we need a temporary hearing, it's going to take 30 to 60 days to get a temporary hearing. There's a 6-month discovery period, which either side's entitled to in order to gather all the evidence and get ready for trial. And then you have to deal with the court's calendar and how soon they can get to you. A contested divorce can take a year, sometimes 2 years, to get finalized. However, if you have a good attorney and your attorney can negotiate with the other side, either through their attorney or through the other party or through mediation, and y'all can reach an agreement, you can file that agreement. If the 30-day minimum has expired, you file that agreement, you submit all the necessary documents to the court, and shortly thereafter the court can grant that divorce, probably again without ever having a hearing. It's important that you try to find solutions outside of the courtroom if possible, because a divorce through court can be very difficult and take a lot of time. One of the things that can speed up a divorce is if you have all the information that your attorney might need in regard to the financial issues in the case, the income of the parties, the debts of the parties, what the assets are, etc. This can expedite the discovery period, and either side, both sides can actually waive the 6-month discovery period that the law allows, so that you can get to a court a little bit quicker. Speeding up a divorce is a difficult process unless you can reach a settlement. It's every divorce attorney's job to try to find solutions for you, to find a way to solve the problem. And if you have a good attorney that can negotiate well, hopefully you can reach an agreement through negotiation or mediation. That's the key to getting your divorce done quickly. Many things can slow down the process of divorce. If the parties are fussing and fighting a lot, if things keep happening, there are new circumstances, custody. Anytime there's a custody battle, it's going to take a while. Either party has a right to demand a jury trial. Georgia's very unique in that you can actually get a jury trial in Georgia on the financial issues. A judge always decides the custody issues, and a judge always decides child support, but a jury can decide all the other financial issues in regard to a divorce. But if you make a jury demand, don't expect your divorce to happen anytime soon, because the jury logs are very backed up, and it may take a year or two before you ever see a courtroom. Rarely do you see jury demands. Usually they're in very high asset cases. A lot of times they're in cases in which celebrities are involved, or sports figures, athletes. Some lawyers will use a jury demand to delay a trial. They'll file it as a tactic, and then they sit on that jury demand and delay and delay and delay, and then at the last minute they withdraw their jury demand. Daniels and Taylor does not do that. We don't think that is a ethical practice. If you want a jury trial, you have a right to it, but I'm not going to abuse the system in making unwarranted jury demands. A temporary order is an order that you obtain while a divorce is pending. Its purpose is to address the issues that need to be addressed, such as custody of the children, temporary child support, temporary alimony, temporary possession of property, temporary orders to pay debts, etc., so that the parties can continue with life and meet the needs of the children and the parties while the divorce is pending. It is an abbreviated hearing. You're only allowed to put up your client and one other witness. You are allowed to present witness affidavits. It's a way of getting some relief. Let's say the divorce has been filed and one party has all the financial resources and refuses to provide any support to the other party. Then you need a temporary. If the parties are fussing and fighting over who's going to have the children while the divorce is pending, you need a temporary. So that's what a temporary order does. It just gives you some release on the short term. They last until modified by the court or until a final order is put into place. The best way to expedite your divorce case is listen to your lawyer, cooperate with them, do your work. What the lawyer asks you to do, do it. If they give you forms to fill out, financial affidavits, do it. We always ask the client to sit down and kind of tell us their story in writing. Do it. Why do you ask for it in writing? Well, I ask for it in writing because I want the client to sit down and think about it, not just sit and talk. I ask them to answer the questions: who, what, when, where, why, and how. If they answer those questions, tell me their story, give it to me in writing, I read through it, and then it cues me to ask follow-up questions so that I gather all the information as quickly as possible. Everyone's concerned with how long a divorce takes. They want to get it over with, but the best way to do that is to contact an attorney and get the process started. If you need some advice in regard to your divorce, Daniels and Taylor is here to help you. Give us a call.